From supplementary list 1, pronouncement of judgment.
The employee has not produced any document with regard to his daughter's illness, and his absence from duty has also been established. However, taking upon the petitioner has already been reinstated in service pursuant to the orders of this court, and there is consensus arrived at it is expected the employee shall discharge his work without going in on leave and without proper permission, as has been done earlier. In case he is found to be absent for any reason in future or commit any other misconduct, the entire period of absence mentioned in serial number 1 to 6 Supra will have to be treated as fast track, and there is no impediment for Assam High Court to impose a major punishment after issuing charge sheet following the other procedures in accordance with law. It is made clear that clearly because this court has passed an order modifying the punishment, it does not mean that repercussions are maintainable, and because the consensus arrangement between the parties and to avoid mental agony to both the parties, this court has modeled the relief. Had the parties had not consented for amicable solution, this court would have certainly dismissed the WP number so and so, giving liberty to the department to proceed with the inquiry, which may ultimately end in dismissal of the employee, as the duration of his absence is huge. It is further made clear that the period of absence has not been treated as dies non, and for the services not rendered, the period will have to be treated as no work, no pay. In the result, writ petitions are dismissed. Dear, please.
From the main supplementary list, item number 1 to 4.
1 to 4.
Made be your worship, Lord.
Yes, sir.
My Lord, your worship, may kindly take up item 4, my Lord.
Sir?
Your worship, may kindly take up item number 4, my Lord.
Item 4. Oh, this is where we have asked you to deposit 2 crores or
No, my Lord. This is
This is different matter.
This is new matter, my Lord.
Madam, 4, item 4. 4 is this. Yes, sir.
My Lord, this is a matter, my Lord, where the industrial policy was announced by the government of Meghalaya. And your worship may see, my Lord, the page number 42, my Lord. It starts with page 42.
Page 42.
My Lord, and 11 part at page 53, my Lord.
Meghalaya Industrial and Investment Promotion Policy.
Well, this is an industrial policy, my Lord, where, my Lord, the promise was made to for sales tax exemption, and also it was, my Lord, mentioned that on introduction of the GST.
No, in page number 42, it is Annexure 3 starts. Which page, which paragraph you are referring to?
My Lord, page 53, my Lord.
63.
53,
53.
My Lord.
Yes, sir.
Clause 2.7, my Lord.
Huh?
Clause 2.7.
2.7, yes.
My Lord. Sales tax and VAT remission. The state government shall promise 99% of the state VAT remission to the eligible industry. So you're also may skip over the last line, my Lord, last paragraph. This one. In case GST becoming applicable during the tenure of this policy, the above said concession shall also extend it to the state GST only. So it was promised that in case the GST is enforced, then the state concessions shall only be applicable and will be given to the state GST. Thereafter, my lord, the promotion policy was announced, which you also find page 57. And at page 69, my lord, the similar announcement was made. '69, my lord, clause
Last
7.
sentence. Last line, para 7.
My lord. Now, in pursuance to that, my lord, the petitioner established his industrial unit. The eligibility certificate was issued to the petitioner, and thereafter, my lord, on the GST coming into force.
Who's taking notice?
I am taking notice, my lord. Now, only issue, my lord, is that similar matters came before your lordship concerning the central government policy also, my lord. And that matter has travelled up to the Honorable Supreme Court also in this matter regarding promissory estoppel, my lord, because the case of the petitioner is based on promissory estoppel, my lord. Now, this issue was, my lord, pending identical matters came before your lordship, and your lordship has disposed of the matters by passing the order.
That was a different case in a Hero Honda case, my lord. Your lordship issue notice, it will satisfy your lordship that that case has no connection with the present case, my lord.
Your lordship, may kindly see. Both the petitioners and the union agree that the principal issue arising in the present set of proceedings has been answered by Supreme Court in the judgment of October so and so, my lord. It is fairly submitted on behalf of union that Supreme Court has dismissed the challenge to a notification of October 5, 2017. It has permitted the private parties to make representation to appropriate state government and GST counsel for 42% subsidy that were available prior to GST regime coming into place to be restored. There is no dispute that a mechanism has been arrived at union to reimburse to the manufacturer's share of union about 58% of subsidy that existed prior to the present regime, are disposed of by taking on record a aforesaid Supreme Court judgment and leaving the parties, the writ petitioner in each case, free to approach the appropriate state government and GST counsel in respect of balance 42% subsidy that they were entitled to prior to the present regime being put in place, my lord. And Hero Honda case is, my lord, here.
I think my learned friend has not gone through the issues which were there in the case.
Your lordship will see.
I just submit in the Hero Honda case, what happened, my lord? There was a 100% exemption or value addition. Now, after the GST came into force, the central government said that 40%, 44%, 42% we have to give to the state government, and thereby will only reimburse 58%.
Now,
You file your,
I'll file
because we are not granting any interim order.
yes, lord, I will file.
No, there is no interim order. I'm not paying for interim order also.
That is right.
We'll place.
Notice.
In all the four cases, you know.
It is first week of July,
First week.
4 weeks.
First week of July.
4 weeks.
Your lordship may have it after 15th June, my lord, any day, 15th June.
15th?
June, my lord, after 6
Oh, sorry, June. Sorry, we are in the month of May. I'm seeing this calendar, thinking that we are in June. Yes.
I'm highly obliged, you know.
So after 15th June, give some date.
Grateful.
Item number 5.
Sometimes the displaying the wrong page in the calendar gives
Because for lips.
Please, Your Lordship, appearing for the appellant in item number 5. This is our appeal under section 37 against the order of 15th February passed by the District Commercial Court. Our application for condemnation or delay is listed today.
How many days delay, madam?
Your Lordship, it's just a delay of 3 days. It's the delay which was caused due to the certified copy coming. That's
3
it.
days delay.
Yes.
Do you have any objection?
Delay is not actually 3 days, it is 33 days because it's a impute judgment is passed by the Commercial Court and Commercial Court Act will be applicable here, and section 13 says limitation period for filing appeal is 60 days. So here they have counted 90 days initial period. So that is
Is
the
the appeal under 37?
appeal under 37.
Oh.
So I accept notice, let the matter come on the next date. 3 days or
Lordship,
33 days
silence.
possibly may not matter much, but let me seek instruction, Your Lordship.
But 3 days or 33 days is not bad. We can understand with 330 days.
I
We have any objection for 33 days, even assuming it's 33 days.
Lordship, let me seek little instruction because this is the first time I am appearing in this matter.
Yes. So also takes notice.
Lordship, if I may, Your Lordship.
Yes,
The
madam.
order was
Just
the order
to-
was pronounced on 15th February. So 60 days, we filed it on 18th April. So we're counting it as 60 days only, not 90 days.
There
But
is,
anyhow, let him take notice. Coming on the first time, let him take notice.
Yes.
Whether it's 3 days or 33 days, we don't find, no, it can be condoned.
yes, only a thing, it
Whether
has to
we'll
be,
see whether your calculation is correct or not.
Absolutely, Lordship.
Lordship, after 2 weeks.
Many lawyers and judges are very weak in mathematics. So the calculation is
Lordship, I
always wrong.
understand you and I'm learning.
Yes.
Obliged.
Obliged.
And Your Lordship, next day,
Decide the date.
When you want, sir? 2 weeks?
after 2 weeks. And in the meanwhile, I will also file a counter objection.
For the delay.
Not for the delay. Delay will be condoned. Only just I want to inform them.
The 37, whether they want a right to be heard here, we'll see.
Right.
But anyway, it's different from 34, you know.
Yes.
Yes.
Because they have come only against the interest component, which is declined by the 34 court. Rest of the awards are upheld. So if they are challenging that portion, one portion of the award, I will have to challenge the second portion of the award which has gone against me.
Anyway, we'll see. Yes.
Hallelujah.
Post after 2 weeks, sometime last week of this month.
Item number 6.
This also takes notice of the request. Post the matter. Last week of this month, madam.
Lordship, last week we won't be available. If it can be on the second, can be in the second week of June.
Second week of June. For condoning the delay.
Or any day before the last week, Lordship, that's it.
Take it down last week. Yes. Will come up next week.
My lord.
Thereafter, I'll give you time.
My lord.
Item number 7.
Same.
Delay condoned.
The petition, they didn't mention the date of delay, but I was 700 days.
700 days delay.
No, no, sure, absolutely.
What is it? This is a POCSO?
So, my lord.
What is the age of the victim? Nothing was last case. Last one.
May it please your lordship?
The instruction comes to it. Oh, apart from this, one more supplementary. Sure. 11. Ah. Yes.
Lordship, as per the instruction from the airport authority, Lordship, the work by Garuda UAV Private Limited has already been started. And ground survey has been started, and aerial survey is scheduled with effect from 8th of this month.
8th of
8th of this month, Lordship.
for survey.
Yes, sir. Yes, Lordship, for aerial survey.
Leader survey.
Huh?
The leader survey.
Their survey.
Yes.
And
What about the report that got to be filed, after inspection, Ladakh and
My lord, because initially there was one more airport similar, so we are thinking that we'll make a comparative chart of
so after seeing
that one. Yes, my lord. Otherwise, then these two will be incomplete.
Yes.
That is the reason, my
when a
lord.
matter is taken up for hearing, the council so representing airport authority submit that the survey will commence on
8 from the 8th of this month, Lordship.
from 8th of May. The council appearing the appellant,
Yes, amicus, my lord.
the amicus would submit that even though inspection has been completed at Ladakh and Port Blair, between 10th and 17th,
10 to 17, yes, my lord.
between 10th and 17th of April 2024, a detailed report will be submitted after inspecting the other
Yes.
place, namely Paro. And that the amicus would submit, the amicus would further submit that the composite report will aid this court to come to a definite conclusion
Right.
on the issue in question. Post the matter. Shall I post on 16th?
16th of June.
This month.
This month. my
This month, we'll, after inspection, we'll know. Thereafter, we'll give you time.
Yes, my lord.
We can record it that the inspection has been completed and we'll give you 1 month time for you to submit a report.
My lord, my lord.
Well, on 16th.
16, my lord. Obliged.
Highly obliged.
Item number 11.
Any development with regard to the inspection at Paro?
I'm sorry, my lord.
With regard to inspection,
Yes.
the scheduled. Next
Schedule.
week is they're through or not?
My lord,
Permission has been obtained.
the necessary particulars must have it's been forwarded, my lord. We'll have to check with the RG, my lord.
State, they will be doing,
No instruction. Lordship will come back with instruction at this moment.
So don't give the date. Depending upon what they're going to say, they will give the date. Yes.
Item number 11.
Lordship, this is a sincere apology on the part of, on behalf of learned DSGI. Due to some personal difficulty, he could not appear before this honorable court, Lordship.
So this is the matter we heard.
Yes,
The
Lordship.
lawyer from
It's a part
Tom
of
Delhi.
Lordship.
Lordship, I pray if this matter can come up on Thursday.
on Thursday.
Yes, Lordship.
At the request of the appellant. Who's the matter? Even though the matter has been heard at length, for further submissions of the appellant and the counsel for both the parties have addressed the argument. For further submission to the appellant, the matter is posted today the council sought time during the last occasion. And at this instance, the matter is posted today. When the matter is taken up, the counsel representing the arguing counsel stated that due to personal reasons, the arguing counsel is unable to be present and sought time to 16th.
Yes, Lordship.
Oblige, Your Lordship.
Kindly oblige.
Single, two matters.
Only one, sir.
Two.
Yes, two.
Yes.